So basically what I'm talking about is the obligation frequently referred to as the Osborne obligation, the obligation on a state authority to take preventative measures where the authority knew or ought to have known of a real and immediate risk to the life of an individual or group of individuals. You'll all be familiar with the Supreme Court decision in Michael earlier this year. That case perhaps underscores the importance of the Article 2 operational obligation, because as you will all know, and I don't have time to talk about it in detail, Jude is here if you want to ask any questions about Michael later, who appeared in that case. But as you know, that in that case, the Supreme Court declined to find that there was a duty of care in those circumstances for the police to act to protect Ms Michael when they received emergency 999 calls as a result of the threat to her from her former partner. But both the Court of Appeal and the Supreme Court were prepared to let the Article 2 operational obligation case proceed. So it's an illustration of how, in the current legal landscape, in many instances, it's going to be easier, if that's the nature of the complaint, that police or other relevant state authority fail to act to protect your client or a member of your client's family. It's generally going to be easier these days to think of it in terms of an Article 2 claim rather than a negligence claim, unless it falls within those limited categories where duties of care have already been acknowledged. It is an area where there are likely to be further legal developments. I'm going to flag up a number of them as we go through, but I would suggest that it's underscored by the fact that when you go to the very back section of the paper, the last 3 pages or so from it's page 57 onwards, we identified 10 areas where we thought it is likely that test cases and test points in litigation are going to arise in the relatively near future. 5 out of those 10 arise in relation to the operational obligation. And obviously one could think endlessly of others as well, but that's an illustration of the kind of grey areas that have still to be clarified, and the scope for potentially extending the case law in this area. I've so far referred to Article 2, but save where I indicate to the contrary, everything I say about the operational obligation in relation to Article 2 applies to Article 3 as well, save that obviously there the risk in question is not one to life, but is one of harm or treatment that would be sufficiently severe to cross the Article 3 threshold. I'm not going to talk about every element in this section of the paper, but I want to highlight some elements. The first element to highlight, which is alluded to in the first paragraph of that section, is the Sargenston case. It was a Dyson Godella case. I'm not sure, looking around the audience, if anyone involved in the case is here, but anyway, a good case for claimants, which I imagine the vast majority of you are familiar with anyway. But just by way of recap, of 2 important points the Court of Appeal decided in that case. The first was that the risk in question did not need to be one concerning an identified or identifiable individual. When the duty was first articulated by the European Court of Human Rights in the Osman case, the court talked in terms of a risk to an identified individual. And thus defendants have subsequently sought to argue that the duty only arose in such cases, and that was material on the facts of Sargenston. However, the Court of Appeal was persuaded by reference to European court decisions since Osman that it would be wrong to treat the duty or the obligation as only arising in those circumstances. And the court said the reference to an identified individual in Osman was simply because that was the facts of that particular case. The police knew or ought to have known of a particular threat to the Osman family from an individual called Paget Lewis. In the intervening period, there have been a number, as I say, of Strasbourg cases, perhaps most notably a case that, again, I suspect you may all be familiar with, called Mastro Matteo, which was a case where prisoners released on a temporary prison leave had committed a murder. The murder was a random one in the sense that it wasn't that the chap who was murdered was in any way known or linked to them. So insofar as there was a risk to life, it wasn't a risk that the authority should have appreciated related to any particular individual. If there was a risk, it was one that arose by nature of the violent tendencies of those particular individuals. And the court in that case, although the claim was unsuccessful for other reasons, the European Court in that case has said that it was no bar to the Osman principle applying, that the risk was not to any identified individual. Now in the Sargenston case, the risk was nonetheless fairly closely defined because the risk came from a gang armed with baseball bats who were attacking the occupants of a particular house. In a sequence of emergency 999 calls, eventually a person in the house who was being attacked was named, and that was the issue in that case. Did the Osman obligation arise right from the start when the threat was first notified to the police, or did it only arise when the individual was named? As I say, it didn't need to be a named individual, but in any event it was quite closely circumscribed threat because it just related to the occupants of the house. However, seems to me that on the authority of the Italian case I just referred to, Mastro Matteo, there is no reason why the class of those under threats needs to be confined in that way at all to a small group. So we've got no domestic authority on that yet, but on the principle identified in Sargentson, it ought to be enough that if the relevant authorities knew or ought to have known of a real and immediate risk of death, that should suffice.
Heather, I'm Dan Rubenstein from
Hi, Dan.
Stewart. Hi. I need to draw your attention and everyone's attention to a case I was involved in, Hodgkin and Oxley's NHS Trust. Barrister was Stephen Cragg. And the facts were, I think known to most people, Sally Hodgkin was hacked to death in Bexley High Street by a woman who was later convicted of murder. That woman had recently, 2 hours before, attended hospital to say that she represented basically a threat to the public. We issued proceedings, it was an Article 2 claim, and the trust defended it on the basis that we didn't have a claim in law. However, the appeal decision in Sargentson came along, and one of the cases coincidentally mentioned by ourselves and a few minutes afterwards by the defendant's representative, implicitly accepted that Sargentson would have an impact on their ability to defend the case. And after a 6-hour mediation, a settlement was reached. I'm not at liberty to say how much for, but it was well into 5 figures. So, in other words, Sargentson had a direct bearing on their ability to defend the case.
Thanks. Well, that's really helpful. I mean, that's a good example of precisely that point, isn't it? So thanks for that, Dan, that the threat was there, the threat was known or ought to be known about because the woman herself, as it were, self-declared the risk she was posing, but it wasn't a risk to any specific individual or narrow class. It was basically anyone who potentially came into contact with her.
She travelled about 8 miles by bus before committing murder.
Yeah, okay, thanks. That's really helpful as underscoring the point. But one can imagine there might be more litigation in that kind of area, and defendants arguing, well, Sargentson, as I say, did involve a particular discrete group, occupants of a particular property, but certainly the Court of Appeal decision is not expressed to be limited in that way. The next area covered on the paper is the question of what amounts to a real and immediate risk. I'm not going to spend a long time on that because there's been case law on that for quite a period of time, and I imagine you're generally fairly familiar with those concepts, but this is paragraph 42 onwards. But just very briefly, real means a risk that's substantial or significant, but it's clear on the authorities it doesn't have to be a risk that's more likely than not to eventuate. And we've referred by way of example to the Rabone case, where the risk in question of the applicant's adult daughter committing suicide, which was a risk which unfortunately came to materialise. The risk in question was in the region of 5 to 20%. So significant, but it doesn't necessarily have to be all that high. What does immediate mean? Rabone says it means present, or Raybone, it seems to be a split view as how you pronounce that case, has to be present and continuing. In that case, the Supreme Court rejected a proposition that it needed to be an imminent risk. One of the test case points that we identified at the end of the paper, it's paragraph 2 of those points, is what about a risk that's been present in the past? The example given there is what about somebody who posed a risk of violence to another individual, but they're then convicted as a result of their activities, spend time in custody, they're then due to be released. Can you argue, if you're acting for the person who was previously the subject of their violence, can you argue that an Osman duty arises from the sheer fact of them being released back into the community, or would you need something more concrete than that? Now, of course, every case is fact-specific, but I don't think the sheer fact that the violence took place sometime in the past precludes the Osman duty for arising, because there doesn't have to have been a recent manifestation of the threat, provided it's an existing threat as opposed to one that will only arise in the future, then the test is potentially met. Which would mean, therefore, I think that you'd be into fact-specific considerations such as, you know, perhaps to what extent, whilst the person was in prison, they'd admitted responsibility for what they'd done and shown some evidence of rehabilitation or otherwise. Source of the risk is the next topic on the paper. That's pretty clear. It can be a risk of self-harm, a risk from a third party. Paragraph 47 for Article 2 to apply, it has to be a risk to life. But as I've already alluded to, you can obviously plead Article 3 in the alternative if there's a risk to serious harm. The area where it becomes important to focus on Article 2 is normally inquest. If it's, the argument is that Article 2 is engaged for the purpose of the inquest, then obviously Article 3 is not going to be of relevance, and you are going to have to focus upon whether the risk in question amounted to a risk to life or not. We next cover knowledge of the risk. It's an objective test, so it's not just what the authority knew, but it's what they ought to have known. And again, a test case point that we flag up, it's subparagraph 3 of those test case points at the end of the paper, is to what extent, if at all, can the knowledge held by two different state bodies be aggregated for these purposes. Sort of an issue that arose, albeit not in the Supreme Court, in Michael, in the negligence case, where two police forces were involved in the emergency response or lack of response to the 999 call. To what extent could the second police force, to whom the call was rerouted, to what extent could they be fixed with the knowledge of the first police force? Obviously, as I've said, in any event, within the terms of the principle, a body is fixed with that which it ought reasonably to know. But is there an argument for saying the nature of the obligation is one on the state, and that therefore there's some kind of broader concept by which the knowledge of one state body applies to body B, the one that you are claiming was at fault in not taking action? No case law on that I'm aware of at the moment, but an area that one can imagine could arise. I guess it may arise. I'm not actually sure if the Michael claim is proceeding to trial on the Article 2 claim. Do you know, Jude?
I think it's still trying to figure out funding.
All right. Yeah, because I just wondered then that issue might come up in that context. Then the next issue which we flagged, which is paragraph 49 onwards, which we see as a growth area, right for expansion, is the circumstances in which the Osman operational obligation can apply. Clearly it applies in conventional detention type situations, whether it's police, immigration, compulsory mental health detention and so on. Clearly it applies in circumstances to bodies such as the police, who have potential responsibilities for providing protection from threats of violence. To what extent does it go wider than that? We've set out some examples in paragraph 49 of quite broad situations in which the European Court of Human Rights has been prepared to find that the Osman obligation applied, subject of course to the criteria we've just discussed of knowing or ought to know of a real and immediate risk to life. On the other hand, it doesn't apply to any situation when that criteria might be shown. It's clear from Strasbourg case law it doesn't apply, for example, in medical negligence cases. It's a case called Powell versus United Kingdom. I'm not sure if that's on the sheet, but anyway, that was a case which confirmed in Strasbourg that the operational obligation doesn't apply in medical negligence cases. You know, if someone's on the operating table about to die, you can argue that in those circumstances there's a known real and immediate risk to life. And underlying all of this is, of course, policy decisions. So the question then is, where do you draw the line? What are the circumstances? How wide can you take them in which you can argue the Osman obligation applies? The one domestic authority to consider that in any detail is the Supreme Court decision in Rabone, where the court had to consider whether the Osman obligation applied in relation to a voluntary mental patient as opposed to a compulsory detained mental patient, and the court held that it did, for reasons that we've summarised in paragraph 52. But more significantly for present purposes, there is a detailed discussion in that case, which we've alluded to in our paragraph 50, as to the circumstances in which the duty will arise and what are the touchstone, because what the Supreme Court was saying as well, you know, these Strasbourg cases are very interesting, but there isn't actually any clear principle in them as to when the obligation applies. And the Supreme Court identified three features of particular importance. One, where there had been an assumption of responsibility by the state for the individual's welfare and safety. And assumption of responsibility in that sense is being used in a much broader sense than in a kind of negligence sense, where it means something much more specific and clear-cut and usually express acceptance of responsibility. Secondly, situations where the individual is vulnerable, children, the aged, and so on, even in situations where the state can't be said to have directly assumed responsibility. Thirdly, cases where the risk faced by the individual is exceptional, of which examples of that, for example, would be the waste disposal site posing a threat to the safety of people living next to it, which is the Turkish case referred to in the previous paragraph 49 of the paper. So, having given that guidance, it remains to be seen how that will be applied by the court in the future. If you get one of those cases which is in that kind of grey area as to can it be argued that an operational obligation applies or not. There's only one case that we're aware of that's considered this issue since Rabone, and that's a case referred to at paragraph 53 called Kent County Council and the Majesty's Coroner for Kent, considered in the context of an inquest and therefore only looking at Article 2, was a 14-year-old who died from a apparently inadvertent methadone overdose. The 14-year-old was a child, had been recognised as a child in need by the local authority. The parents had been urging the local authority to do more. They hadn't done very much. Query whether the Osman operational obligation applied. And the court held that it didn't, because they said, well, the local authority's got 5,000 to 6,000 children in need in its area, and it can't be right that the operational obligation applies in relation to all that great number of people. However, I have to say, I don't think it's a terribly satisfactory decision. There's no discussion of the detail of reasoning for Rabone in that case, because it might be thought that the boy was classically a vulnerable person and that by the local authority recognising him as a child in need, they had assumed in the broad sense a responsibility for him. Perhaps arguably the court failed to realise in that case that just because the operational obligation is capable of applying in that situation doesn't mean the authority has to suddenly start taking protective measures in relation to 5,000 people, because obviously the obligation only kicks in if in fact there is a known risk of known risk to life, a real and immediate risk, or one that ought to have been known. And then in any event the obligation is only to do what's reasonable. So one might feel, with the greatest respect, that the court's reasoning was a little bit glib in that case. In any event, the Article 2 obligation didn't apply, so one might argue it's obiter dicta anyway. But that's the one case since Rabone that's looked at this area. It's a really interesting analysis in Rabone, and the Supreme Court does say in that case, in terms that this is an area where they expect the circumstances in which the operational obligation applies to expand. So that's that. Then we look at reasonable steps in response. So in other words, what would constitute a breach of the obligation where it arises. I mean, it's a really helpful roundup that Jesse's done there, but I'm not going to go through that in the interest of time. I mean, there are examples of what could amount to breach. The last subject I'm just going to flag up for you is causation. Paragraph 57 here gives a cross-reference to later in the paper, but insofar as it relates to the operational obligation, I'm just going to touch on it now, because this was the second point that emerges from the Court of Appeal's decision in Sargenston, which, as I've alluded to earlier, was a case which related to the police failing to respond more promptly to a threat posed to occupants of a particular house by a gang wielding baseball bats. An internal inquiry found that the police response was unacceptably slow by 11 minutes. The argument on a strikeout in Sargenston was, on the part of the defendant, was, well, the claimant can't show that would have made a difference anyway. Even if the police had set off 11 minutes earlier, can't be shown that that would have prevented the attack, and therefore the claim should be struck out. And that argument succeeded in front of the county court judge. The Court of Appeal reversed that, saying in effect there is no causation test when it comes to liability. They say you simply judge it on the point when the risk arises. So provided the known or ought to be known of a real and immediate risk test is met, the question is then, at that point, knowing what they knew or what they ought to have known then, did the police respond by taking reasonable steps to provide protective measures against the risk? The question of whether in fact it would have worked or not is irrelevant. However, didn't have to decide at that point, but the court flagged up that they thought that it would be relevant to the question of quantum. So in other words, at the quantum stage, a defendant would be entitled to say, well, you know, even if we had taken these steps that you say we should have done, but we didn't, it actually wouldn't have made a blind bit of difference. Arguably, that approach to causation is different to approach indicated by some earlier Strasbourg authorities and as reflected in dicta in the House of Lords in the Savage case and in the Van Collie case. But I mean, I was in the House of Lords in Van Collie appearing in the companion case, the Smith case, about duty to care, and I mean, I can be pretty confident, as best I can recall, there was no oral argument on the point at all. And the only issue in the in the printed cases was the defendant's contention that in fact a domestic style balance of probabilities test should apply, and in response the claimant was saying, no, look at these Strasbourg authorities, it's enough if the authority has acted as they should have done, if it had a significant chance of averting the harm. So Savage and Van Col use that phraseology or similar phraseology to suggest there is some kind of causation test, but I say in a context where the point wasn't argued in any detail, and where certainly in Van Col the only issue was, is it that causation test or a more demanding one? There was no issue as to, no contention that causation simply isn't in the frame at that stage. What I do find a little bit odd, though, is that in Sargenston, although Van Collie was cited, there's no reference at all to that line of authority in the court's judgment, which I mean might mean that it's vulnerable in the future. And so again, that's another of our test case points we flagged up in the latter part of our paper. Right, that does me for a canter through the operational obligation and the end of the starter. Subject, I don't know why I keep obsessed with food today, but anyway.
Page 20, I'm going to start on the procedural obligation, and I'm only going to cover the procedural obligation, and I'm only going to cover 3 points within it. So first, Article 2 and the issue of when the procedural obligation arises automatically. Then I'm going to cover briefly historic violations that can trigger the procedural obligation under Articles 2 and 3. And then lastly, the investigative obligation in Article 3 after DSD, and whether there is a clear or clearer position about what that obligation is, or whether it's less clear. So, paragraph 67 at the top of page 20, I've set out there what has broadly been considered to be a statement of understood reading of the case law for a long time. The obligation to conduct the investigation into a death arises automatically in a range of cases, and the reason it arises automatically, it's sometimes said it just arises automatically, it's sometimes said it arises because the possibility of state culpability and system failure is inherent in the very circumstances of the death. For example, shootings by state agents, suicides in custody, killing of people in custody by fellow inmates, deaths of military conscripts, deaths of mental health detainees. This issue arose, and I've set out a number of the cases for a specific reason, which is this issue arose in the Letts case. I'm not going to go through what that deals with in relation to inquest fundings. That's not really the purpose of this session. But the Letts case said that there are categories of case where the procedural obligation arises automatically and indicates the sorts of cases where that applies. Now, I haven't flagged it up specifically, but the issue of whether deaths in custody as a category give rise to an automatic obligation is, I think itself, not an entirely settled area. Most, if not all, of the cases deal with suicides and killings in state custody, rather than, for example, natural causes type deaths in custody or related, not so obviously violent, if I can use that phrase, deaths in custody. And the reason I cited so many cases here is because there are a number of pieces of dicta from some of these cases where the phrase all deaths in custody is the phrase that's used, but it's often decided in the cases in the context of violent deaths, suicides or killings. Now, in Letts, the court specifically said that the implications of that judgment were narrow, that the court was not saying what the implications were for deaths in custody. It specifically said there may need to be other cases to decide whether deaths in custody fall within the automatic category of cases. And it is worth pointing out that because many of the cases come from violent type deaths, there is the possibility of an argument being run that natural causes deaths in particular, but related types of custody deaths, don't attract the automatic category, and then you get into problems about the operational obligation if you can't show it on the facts. This particularly arises in inquests, and that's part of the reason that I've just flagged it up, because of the Letts case. And for those who do inquests, you may already be aware, the ECF funding guidance from the Lord Chancellor has recently been reissued to take into account the Letts judgment. So it removes the reliance on showing an arguable breach, and that being the entirety of the test, that you have to just constantly show an arguable breach, and identifies that there is an automatic category of case. I haven't killed any more trees along with this paper to print you all a copy of it, so just flagging it up for those who do inquests. But it refers to at least, and then lists the kinds of cases where automatic obligation will arise: intentional killings, violent deaths and suicides of persons detained in police or prison custody, and all violent deaths and suicides of persons detained in mental hospitals. So it deliberately doesn't include natural causes or slightly wider sets of cases, and I think there is probably going to, but there is definitely scope for a case on that point. It may come through this funding issue. I also think that the Chief Coroner's decisions when he sits in the High Court give quite a strong indication that he wants there to be a case on this point, so that he can say that natural causes deaths don't give rise to an automatic obligation. So I think there's a case there. How likely it would be to win, particularly if it came in the inquest context, because the Chief Coroner would probably hear it himself, might be a bit more dubious. That's all I wanted to say on the automatic set of cases. If I can turn over then to page 22. It's a relatively niche area, and the case law is also quite complex. But paragraph 76 is an attempt to identify some of the principles and scope for possible cases around historic violations. So this is particularly cases where the death or ill treatment that passes the Article 3 threshold took place prior to the 1st of October 2000, so prior to the coming to force of the Human Rights Act. The paragraph 76 summarises it. The current position in domestic law is that there's no obligation to conduct an inquiry into a death prior to the coming into the force of the HRA, or to reopen HRA, pre-HRA inquiries that didn't comply. Now, there is some comment in McCaughey, which is the main Supreme Court case on this issue, which raises a few possible exceptions, if you want to call them that, or issues that you might want to raise. The first, at number 1, is very, very unlikely to arise anymore. It tended to arise in relation to cases where there was an ongoing investigation pre-HRA that carried on afterwards, but obviously the further we get from the 1st of October 2000, the less likely that is to arise, so I'm going to skip past that. Subparagraph 2. The Supreme Court in McCaughey appeared to recognise that the procedural obligation can be revived where, after October 2000, so after the Coming to the Force of the Human Rights Act, a plausible, credible allegation, piece of evidence or item of information comes to light, so essentially new evidence, which is relevant to the identification and prosecution or punishment of those who are responsible for the death or ill treatment. Now, in an Article 2 case, that's probably more likely to be possible to show than an Article 3 case, mainly because in an Article 2 case, most of the kinds of cases that engage Article 2 involve the state in quite a strong way, so the state's often going to have much of the material that's relevant to the possibility of new evidence coming to light. But one of the cases, Brecknell in the UK, is a case involving new evidence coming to light of state complicity in a death during the conflict in Northern Ireland, and that's an example where it's not just through state agents that new evidence can come to light, which then raises the issue of needing to further investigate. I was also thinking about this in relation to Article 3, because the difficulty with Article 3, of course, is that if, for example, you have a case involving abuse or some form of serious ill treatment on an individual who then doesn't die, they are obviously going to have known at the time that they suffered that form of ill treatment, and by definition, they may well, if you're making allegations that are new, have not reported it at the time or inadequately reported it at the time, which might be a bar to trying to open new investigations. But if you think about historic abuse allegations, you could envisage situations where new evidence might come to light about, for example, a pattern of behaviour at a particular institution that led to institutional abuse that you didn't know about pre-HRA, which you then found out about post-HRA, which might trigger the possibility of further cases and further investigations. And equally, there obviously can be Article 3 type cases where the state is the body in charge of the information, and it's only come to light a number of years later, which could then potentially trigger an investigative obligation. It's worth pointing out that even the comments that are made on this issue, which are by no means definitive on this point, they do suggest that even if you can trigger a re-investigation or a new investigation, it'll have to be fairly flexible as to what you're entitled to. So it may be that you get a lot less than you would get in a normal Article 2 or 3 investigation. I think the last point to make on this is that there is a Supreme Court case on related issues called KU, which I think has been argued. Adam, who's sitting at the back, was in it, and I think judgment's awaited, so that may change everything I've just said. But I just thought I'd flag it up. Partly because the cases can be quite fiendish to understand, particularly the Strasbourg cases and the way in which they've been interpreted by the Supreme Court. I'm going to move forward and spend a little bit of the time I've got left on DSD. So if we move forward to page 34, you probably will know the DSD case from the High Court. The issue is the duty to investigate, and in that case on the police, in relation to allegations of ill treatment that meet the Article 3 threshold. Now, paragraph 100, the obligation to investigate arises where the authorities are provided with credible or arguable allegations, or where there's a reasonable suspicion that treatment in violation of Article 3 has taken place, including in circumstances in which the alleged violation was perpetrated by a private individual against another private individual. That might seem straightforward, but particularly the aspect of private individual against private individual acts triggering that obligation has been contested, and that's now been, so far as it's got to the Court of Appeal, it's been settled in domestic law. It's worth bearing in mind, if you look at paragraph 101, I'm sure you'll be very familiar with that case in the Article 2 context, that obviously an arguable allegation is one that's more than merely fanciful, so the threshold is low as to what would be sufficient to trigger the Article 3 investigative obligation. Now, I'm going to jump around a little bit in the paper just to try and flag up what are the most important, or seem to me to be the most important comments from the Court of Appeal in DSD. So if I move forward to paragraph 107, and essentially the issues that arise in DSD and that come out from it are how rigorous does the investigation have to be once the obligation arises, and what does the state have to do to discharge it? So those are the two questions that DSD is really addressing. 107 is potentially a helpful comment from the court in that case, because the court said that there's no distinction between the content and requirements of the procedural obligation under Article 3 as opposed to Article 2. And there's actually quite a lot of domestic authority which suggests that's not the case. There's been a lot of previous domestic authority saying that it's more flexible and less rigorous under Article 3. That, I think, might be a helpful comment to be used to push for more rigorous investigations in an Article 3 case. The problem with it is that it's somewhat contradicted or undermined by the key thrust of the DSD decision, which is that what Article 3 requires and the rigour of the investigation that Article 3 requires basically depends on the nature and severity of the allegation. So Lord Justice Laws basically says it's a sliding scale depending on the context and the facts of the particular case, which sounds a bit like an invitation to litigation, because he's not setting out specific criteria. He's simply saying it'll be fact by fact and case by case that you'll assess what's needed, and you may need to litigate in order to know whether or not Article 3 required more on those facts or less than what the authority was willing to give. This sliding scale point that he relies on, just move forward briefly, he gives a few examples of the sorts of things he has in mind. So if you turn to page 40 and paragraph 121, so keeping in mind that he's given this idea of a sliding scale depending on the severity of the allegation, and it appears he's talking across both Articles 2 and 3, although of course the case only concerns Article 3, so I suppose any comments on Article 2 over to in that sense. Paragraph 121, the intensity required of the state's investigation varies depending on the nature and severity of the ill treatment alleged to have taken place, with a sliding scale and varying degrees of rigour. And the court said this: particular rigour will be required where state agents have killed or injured in violation of Article 2 or 3. Well, that's pretty obvious to the most serious kinds of cases. Serious violent crime by non-state agents will generally require a proper, i.e. an effective, for the purposes of Article 3, an effective Article 3 compliant investigation by the state. And importantly, there is a mandatory requirement for such an investigation in a typical or paradigm case of serious violence. And obviously that doesn't just include physical violence, it includes sexual violence, because DSD is a case about rape and serious sexual violence on the facts. Subpara 3 there, less optimistic. Not every allegation of ill treatment which meets the Article 3 threshold requires a full criminal investigation. Where all the facts are known, where the victim does not want the police involved, or where the harm is caused by negligence and there's no criminal act, while a full criminal investigation may be required, it may not be appropriate or proportionate or necessary, which is perhaps more concerning from the perspective of claimant lawyers, because it appears to give something of a get-out for public authorities who argue on the fact that it's not needed. But clearly, the subpara 2 there is the one that you're going to be relying on in police cases. It gets more tricky, I would say, in relation to subpara 3 in non-police cases, with local authorities perhaps, or other state bodies that you're arguing need to discharge the investigative obligation by carrying out an investigation. Now, I'm going to move on next and just deal with, in practical terms, how you use the DSD test to try and bring claims against inadequate investigations, obviously in the policing context, but potentially in other contexts. I'll come on to that issue a little bit later, but the test that you're looking at, if you go back to page 38 and para 113, so far we've talked about what triggers the investigation, and then the sliding scale, so the intensity of what's required. Obviously the intensity of what's required is linked to this paragraph, but in a normal or paradigm type case like DSD, where such an investigation is required by Article 3, the relevant test that you're going to apply is about halfway down para 113. The state will be liable where a step that should have been taken but was not taken would have been capable of leading to the apprehension and prosecution of the offender. And capability involves a causal connection between the failing and the ability of the investigation to identify and arrest. So that's not the same as a causal connection between successfully achieving arrest and prosecution. It's just about whether or not taking such a step was causally connected to increasing the ability of the investigation to achieve that outcome even if it didn't in fact do so on the facts. So it's not a but-for test. You don't have to show that if that had been done, the person would have been caught, and, for example, the harm wouldn't have been sustained, or simply that the person was then prosecuted. It's about looking at the focus is on the investigative steps that should have been taken at the time, rather than on the outcome. Although obviously the outcome is relevant because you have to consider whether it would have been capable of increasing the prospects of that outcome. Now, the kinds of practical issues you're going to be looking for are obviously the sorts of things you're probably already doing in the kinds of cases that you do. So you're looking at inadequacies by the police in doing things like failing to take witness statements, failing to gather relevant evidence before it becomes perished, linking cases together to show that there's a pattern of offending, which will help you to identify the relevant offender, which is obviously a huge issue that arose in the DSD case arising from the war boys offending. One matter that helps, well, there are a number of matters from the DSD judgment. It's worth going back, and I know people probably always say this, but the DSD judgment in the High Court is extremely long and very factually specific. It's quite hard to wade through, but it is very, very helpful as giving an indication of the sorts of things that can result in a violation of the investigative obligation. If you just read DSD in the Court of Appeal, you don't get that, because it only really deals with some of these principles about capability and the sliding scale, so it's worth going back to the original judgment. One of the things that the original judgment says is that when you're challenging an investigation, one of the things you should look at is whether or not the police, or arguably other authority, complied with its own internal guidance. So when you're testing whether what they did met the standard, that's one of the things you need to be looking for, because obviously that's what they're saying they should be doing. If they're not doing it, that's obviously relevant to the issue of whether or not they've taken steps capable of leading to the apprehension of the offender. That's something of an upside. If you turn back to page 41, just flagged a couple of points that are likely to be argued in almost every case, I've thought, by defendant forces and other public authorities. There are two in particular that I have in mind. One is the general statement of principle applied in Article 2 and Article 3 cases that the law shouldn't impose a disproportionate burden on public authorities, and particularly the police. Essentially, the argument that's likely to be run in these kinds of claims is it's easy in the benefit of hindsight to look at our investigation and nitpick through the entirety of it and point out problems, but bearing in mind that we were taking judgment calls at the time, it was reasonable, i.e. therefore capable and meets the standard, or doesn't fall so far below that it breaches Article 3. That's one point. The second, if you move across the page to the left at 123, paragraph 123, and this comes from the Court of Appeal judgment in DSD, is that the court specifically said that the state has afforded a margin of appreciation as to compliance with Article 3. I mean, that's an understood principle that's been around for a long time. The margin widens at the bottom of the scale, and the example given is negligence by non-state agents, including investigative failures, i.e. in a DSD type case, there's quite a wide margin, but narrows at the top, deliberate torture by state officials, very rare cases which are not likely to come up very much, and where for obvious reasons there needs to be a narrow margin because of the severity of the act. In normal investigative type cases, that's obviously unhelpful because that's going to be relied on by defendants. The points that I've already made about internal guidance, about pointing out the sorts of steps that should be taken, and also going back to the facts, which I won't go through, of the High Court judgment, are the sorts of things that you're going to be looking at in order to rebut those kinds of points. Just one final point. I know Heather's touched on a number of the test case issues. There's one in relation to DSD, and it seems to me that if you look at DSD, there's no reason of principle why it couldn't apply to other public authorities. It clearly hasn't, but given that Laws's decision simply talks about a sliding scale depending on the severity of the allegation, it's not specifically about policing function, and so I think there is scope for cases where if you can show an allegation or credible evidence of serious crime being reported or coming to the attention of other bodies, so local authorities, social services, particularly if that should give rise to them reporting that to the police, but for any reason they don't, then you may be able to argue that they have also failed in an investigative obligation because they haven't taken obvious steps capable of increasing the ability of the investigation to apprehend the offender. It also links up, and this is the final point I'll make, with the point that Heather made about synthesising knowledge in relation to the operational obligation. You might get into a similar sort of issue in these sorts of cases because there is a risk that you're going to have a mixture of investigative failures across two, possibly even more state bodies in an investigation, And obviously in Strasbourg, if you bring that case, that'd be fine because you just bring it against the UK. Your allegation would be against, quote unquote, the state, and the state includes police and other local authorities. Obviously in domestic proceedings, you're going to have to bring that case against named defendants, and then there may be issues about whether or not the court likes the idea of trying to establish an Article 3 breach by combining investigative failures, which separately wouldn't be enough to meet the threshold and get over the line, but together might. I don't know of a case that touched on that point. Flagged at the very back of the paper that in the Court of Appeal and Michael, in completely Obert's comments that have no binding authority, the court made a couple of comments about being concerned about this sort of approach, but there is no, I don't think the point was argued, or if it was, this certainly wasn't part of the ratio, and there are no other cases on it. So I think there's probably scope for movement on that as well. I've probably run over my time, so I'm going to leave it there unless anybody has any questions, but if you do, I'll answer them at the end if you want to wait as well. Thank you.
Bear with me because Jesse's paper has drawn out some very interesting discussion points, and given the wealth of experience in this room, we'll be very grateful for your contributions and your questions, preferably those we know the answers to. And it was my job to draw out discussion points in particular from page 44 onwards in the paper. And you can look at that if you want, but to be honest, I dipped in and out of it, so you might prefer to look at my PowerPoint presentation, which are designed to help my ailing memory. And there you'll see that if I did try to discuss all of the topics in Jess's paper, we'd never get a drink. So I have just focused on those denoted with an asterisk: victim status, a little bit on limitation, just enough to put you off your dinner, and something, and particularly on damages, actually, not least in relation to Article 2. Everything I say up here and in the PowerPoint is in the paper, other than where I've put a hashtag. I've used a hashtag mainly because I've never used one of those before today, and I'm reliably informed they're quite popular now. So if there's a little hashtag in the PowerPoint, it means that it's a new authority and you may need the reference. But there's very few of those because Jesse's paper is nothing if not compendious. In relation to then victim status, for those of you who remember the dark days before the Human Rights Act, and I am one of those, you'll remember how frustrating and constraining it was to litigate death claims because of the strictures imposed by statutes such as the Fatal Accidents Act and the like on the category of claimant and on the category of recoverable loss. And what's so great about the HRA is how it opened all that up, and for me it's one of the most important reasons for its retention. And you'll see that when you look in particular at the category of relatives of the deceased at the end there, which is what I want to focus primarily on in this session. But I did want to mention briefly this new category of claimant to me, which I've dubbed the near deceased, because until I read Jesse's paper, I didn't appreciate that the substantive duty in relation to Article 2 can be engaged where someone's life is at risk, but they don't die. And so the examples, for example, in Makaratsis, where there was a police shooting, shot in the foot and various other places following a police pursuit, but survived, and that was run as an Article 2 claim, not as an Article 3 claim. And I think in part that's explained when you read it because of the whole systemic problems in the policing of that particular operation. And then you see Kolyadenko, which is a bit like Onyildis, but not a rubbish dump, but a flood, except no one dies. And again, I can kind of understand why Article 2 is run because no one dies. But personally, for me, it was a new way of looking at Article 2 and opening it up, and not always being restricted to those hurdles that Article 3 can impose. So I just wanted to, I see lots of people nodding, as in I knew all of that already, so I'm sorry to you. But if there's anyone else who didn't know that, I hope it's helpful. In relation to relatives then, that's what I want to spend most of my time on, and that's relatives of the deceased, relatives of those who have died in custody, who have died following police contact, for example, as a result of a substantive breach of the Article 2 duty by a public authority. And you'll know that the Human Rights Act has made that whole landscape much easier to litigate, to secure justice for a much wider and more realistic category of claimants. And that's despite the best efforts of public authorities, including in Raybone, to their shame, seeking to curtail the entitlement of those bereaved. But what's really helpful is that the judgment of the Supreme Court in Raybone has put paid to that, and given a very clear articulation of the duty that arises for those family members in their own right as direct victims, if you need to use that terminology. And Raybone, in addition to the Strasbourg authority on which it's based, gives you quite an expansive family tree from which to choose. And essentially, it's about the intensity of the bond, as we'll see when we look at it in relation to quantum. But certainly parents, as we saw in Raybone and also Van Call, children, as in Savage, siblings, as in, for example, Reynold, unmarried partners, I've given you the authority for that, uncles, aunts, nephews, nieces, cousins, which I hadn't seen before, which is Moussaiev, and I thought I had an authority for grandparents, which is why you will see, if I put up the slide, all those X's at the end, but in fact I couldn't find it. So does anyone have an authority for grandchildren or grandparents? If they do, I'd like to know, please. So, so essentially, when I'm advising, I approach it on the basis that any loved one who is devastated by the loss of the deceased qualifies as a victim. So in that sense, it's a low threshold in that you're not concerned with formal family relationships, but it's a high threshold in that the devastation needs to be marked and serious. And so it's not your distant cousin, unless you're very close to your distant cousin. Although then they wouldn't be distance, I suppose. So that's all I wanted to say in relation to Article 2, unless anyone else wanted to chip in. No? So in relation to Article 3, it's slightly more straightforward. And so the main point I wanted to flag up was the point raised in Jesse's paper about where Article 3 in its negative duty can be used by relatives again. In the case he flagged up of Tumortis in the context of a disappeared person, not a deceased person. And that's relevant in the sense that, again, I'm not aware, and I'd be interested if you are, of an authority where a relative of the deceased person, rather than a disappeared person, has claimed a breach of Article 3 on the basis that the investigation into the deceased relative's death has caused the relative inhuman and degrading treatment because of high-handed or offensive treatment. In Tumortis, that's exactly what happened. It was an extreme case. Any state disappearing your child is. But it really struck a chord with me because, of course, it's not unusual for our clients to be met, maybe not with disappeared children in custody suites, we hope, but with that high-handed, offensive, closed approach, which certainly in my experience has caused clients inhuman and degrading treatment and deep psychiatric injury, often worse than the loss itself sometimes, and certainly in a very compounding effect. So I think it'd be very interesting to apply the principles in Tumortis in a disappeared case where it wasn't clear whether the son was dead or not, to a case where it is. And again, if anyone has an authority on that or a prospective challenge, I'd be interested to hear. So that's all I was going to say in relation to Article 3, unless anyone's any questions or comments. And I just included another slide to show that the facts on Tumortis were serious, obviously, and so you would have to pick the right facts in the right case. A summary then in Article 2.3 is that, obviously, on the appropriate facts, we can have an Article 2 claim on behalf of the deceased estate for failing to protect the deceased's life, an Article 2 claim on behalf of the deceased family for the impact on them of that failure, otherwise known as a grief claim, which is what I want to look at primarily under quantum. An Article 2 claim on behalf of the deceased family for any investigative breaches should they arise, and as we were saying, potentially an Article 3 claim on behalf of the deceased family for a substantive breach in a disappearance or death case. And the other question that occurred to me is whether it might be possible, again on pretty extreme facts I accept, to claim not just C or D, but possibly C and D. I mean, one can imagine a situation where there is an investigative breach, for example, a failure to comply with Article 2 because the investigation is not independent, which obviously engages the investigative duty, under Article 2, combined with very high-handed treatment of the deceased family, which would then engage Article 3. And so, although there's obvious overlap and you may not need to run both points, not least in view of tactics or cost risk, in the right case, and it would need to be extreme one, I thought it might be possible. Jude, you're looking pained back there. Does that seem strange to you? Okay, so that's all I'm going to say on victims. In relation to limitation, which I'm slightly obsessed with, because of course it's what solicitors get sued on most, although thankfully not yet. The first thing I want to do is correct a typo in that third bullet point. It should say 9 September 2016. Not 9 September 2015. It'd be pretty good to issue the day before. And similarly, 10th September 2016. So I'm sorry about that. I do usually diarise my own limitation dates more accurately than that. And the point I want to raise is this. Obviously, Section 7.5 is clear. The proceedings must be brought before the end of the period of 1 year, beginning with the date on which the Act complained of. And 1 year is obviously 365 days. So if a claim were to emerge today, 10th September 2015, and you count on 365 days, you end up at the 9th of September 2016, not 10th September 2016. And the reason I raise that is when I've inherited files, maybe from other firms or just seen lag reports or whatever, often I notice that people do issue not on the day before, but on the anniversary. And I think I'm right in saying you have to be really careful about that, and that's why I'm raising it. So I hope you all agree, and that's what you do, and therefore it doesn't put you off your dinner, but if not, if maybe sort it out. The other point that I have seen a bit recently is people using the date of death in an Article 2 case to run that 1 year less 1 day period from, and not the date of causative breach. And obviously, that's a problem because, say, for example, in a prison death, where the causative breach is the failure to open an act, for example, that might have taken place maybe 3 months before the date of death. And so if you always leave it to 1 year less 1 day from the date of death, that is a potential problem. Now, I have to say, I've seen that done and defendants not taking a point at all, but I have seen defendants take a point, and there can be all kind of arguments where you can say it was a continuing breach or just inequitable or whatever. But given I was asked to talk about limitation, they're my two top tips. Damages. The position in relation to Article 2 is eloquently set out in Jesse's paper, and I have to say it's a really useful roundup of all the principles. And if you're trying to settle a case or you just need a ready reckoner, it's really great to have it all in one place. And thank you for that, Jesse. And it also means I don't have to go through any of it today, which is great. And also, I assume most of you are going to know a lot of it. And if you don't, you can read Jesse's paper. But what I did want to flag up is, and it's true in any case, that although there can be various hurdles to obtaining damages in an Article 2 case, in convention cases, in Article 2 cases, if the breach is established, you're going to get compensation, you're going to get damages. And so, although I think in other articles and other areas of the convention you might want to look at all those potential hurdles, luckily with 2 and 3 we don't need to worry about that so much. What we do need to worry about, though, is securing adequate just satisfaction for our clients once we have established that breach by way of settlement or at trial. And again, the great thing about HRA is it doesn't impose too many hurdles at that stage, in that it names the loss properly that arises for our clients, not least distress. It doesn't have to be psychiatric injury. And that's really welcome. The position in relation to the deceased estate is not that different really from the common law. And again, yeah, you'll see in that it's pre-death pain and suffering and distress under HRA, funeral expenses, that kind of thing. If anyone else has any other ideas than that, let me know. In terms of the damages for the deceased family, then, unlike common law, you can claim purely, as you know, for distress and for grief. Now, I know you all know that, but I'm just flagging it up as an introduction to how we quantify that, because that's what I'd like to look at primarily in this session. And obviously then, as with common law, you can claim pecuniary loss arising in relation to dependency, and unusually in relation to the HRA, any damages for distress or other loss arising from any procedural breaches under the Article 2 investigative duty. And the reason I'm going to focus on grief claims, as they're called, those damages for the deceased arising from the failure to protect their loved one's life, is that that's what we're going to be engaged in most of the time. They're more common, for example, than investigative breaches. And as you know, Lord Dyson has set out the position very helpfully in Raybone, building on the range that was identified in Savage from the Strasbourg authorities. And I'm not going to go through all of these because you know them all already, but what I wanted to do was just offer a few suggestions on how we can, as claimant lawyers, increase the damages that our families should receive by way of just satisfaction. Obviously, knowing Raybone well helps that, and Jesse's paper and all of these factors can be prayed in aid in that respect. But the other suggestions I had were these. When you compare the Raybone range, which, you know, when updated for inflation and converted into sterling isn't that bad, you know, it's up 50 grand at the upper end. With the domestic authorities, it is a little bit depressing because many of them were before Raybone, but you know, they're pretty piffling when you see what our clients go through. But on saying that, once you've updated Van Call for inflation, it is nearly 10,000 per family member. And that is my first tip, in the sense that you'll often find defendants trying to do a job lot and a lump sum. And I know that is a Strasbourg approach, but actually our domestic courts have awarded in terms of per family member. And where you have a family of 3 or 4 or 5 who all have that intensity of bond and who are all devastated by the loss, well then, personally, and certainly for settlement purposes, I see no reason why those kind of figures are not multiplied by 5 and 6 and the number of family members. I'm not suggesting you get that at trial, but it's certainly worth a go. Also, it's important to remember that these domestic awards that will be cited at you by defendants, if they know them, and in my experience they often don't include any formal claim for psychiatric damage, and so often you'll have one, and if you've proper medical evidence, that's also going to increase your claim. The other issues I wanted to raise in that respect, obviously you can add on pecuniary loss, and if you have particularly serious facts, we can rely on these kind of cases from Strasbourg. There haven't been any domestic cases of this kind of order yet, certainly at the more serious end. And again, I'm not going to go through them all, though most of them are in Jesse's paper, unless they're hashtagged. But I found it really useful to go through Jesse's paper and say, well, could I use that for this case, and could my case fit within that? And a lot of them, including, you know, landmines in Chechnya, I'm probably not going to be dealing with next week. But if any of us get instructed in relation to drone strikes, I suppose they might be relevant. But you'll see that some of them aren't, you know, so out there in terms of the kind of breaches that we deal with, including Controva, where one family member got, once updated for inflation, over 20,000. Bechter's got one family member got 60,000 euros before it's updated for inflation, albeit very serious facts, and it goes on. So again, if we as claimant lawyers are on top of that kind of detail in the way that most defendant lawyers aren't, we stand a better chance of securing proper just satisfaction for our families. And my final tip, which many of you will know already, is to remind defendants when they cite, of course, all those Strasbourg authorities I haven't shown you, which are tiny amounts of compensation for really serious breaches, is that usually they're in relation to countries with a very much lower standard of living than this country. And Jesse's flagged up various domestic authorities which make clear that courts, when awarding Strasbourg or HRA awards, should update, if you like, to the cost of living in this country, and I've just added the Supreme Court's guidance in Faulkner. Okay, that's all I was going to say in relation to damages in Article 2. Anybody want to say anything before I go on to Article 3? You're all very quiet. Yeah, okay. Article 3, DSD, as Jesse says, with the wonderful Mr. Justice Green, is the key authority now, and I suppose for most of us we're going to be looking at the 20,000 to 100,000 bracket for many of our cases, and therefore we want to rely on these aggravating features, which again will arise in many of our cases, not least psychiatric harm, duration of failings, systemic failings as opposed to individual one-off failings, and certainly morally reprehensible conduct or bad faith by the state. So my view is that that's the bracket we should be heading for, and potentially above. And it's interesting that even though, of course, aggravated and exemplary damages are not awarded in HRA claims because they're not afforded by Article 41 of the Convention, this language is very much the language of aggravated and exemplary damages. And so all those arguments we marshal in support of those claims for common law cases can be used in effect under these kind of headings. like the common law, particularly in relation to aggravated damages, any reprehensible conduct of the claimant will lead to a reduction, as you would expect. But luckily, there's a long list of factors here that we can use as stick to beats defendants in terms of their misconduct. And I particularly liked in this list the whether the state has drawn the necessary lessons from their misconduct. I mean, that's just lovely to read, really, isn't it? And I can't think of another judgment, including some of the really important judgments post-Thompson-Sue and in Thompson-Sue, where you have that requirement for reflection, if you like, on what they did and to make amends. Not just to punish them, but to make it better, if you like. So I really love this judgment, and these kind of factors will, including in Greenfield, will help us. But what's good to note is that in this last paragraph, the willingness of the state to learn lessons and to discipline state agents won't be used to reduce damages to families. And that's quite right, and that why should families be penalised for the state doing their job, frankly? So that's helpful. And that's all I have to say. Unless anyone wants to say.